Well, uh, I guess if he's couching himself as a centrist, the implication there is that you're to the right of center.
Well, I guess I am undoubtedly conservative as it relates to protecting the constitutional rights and interpreting them as they were written and not legislating from the bench, as I said in the opening. I do smile a little as he refers to big companies because I can't remember ever representing a big company. It's true I represented the Grange and wrote the initiative which passed when I was the last on the election ballot, which allows people in the state of Washington to vote for any position without having to register by party. And I hope you may remember I was asked what party I was in the last time I was here, and I could say at that time both parties had opposed me because I had done this initiative for the Grange. But I don't view the Grange as being a big corporation. If you know these organizations, I do. There are 260 little farmers groups. Yep, I did represent the Farm Association too, and I'm proud to have done both and proud to continue their support. I wrote two of Tim Eyman's initiatives. 747 was a property tax cap at 1%. This county wasn't so bad, but at the time, one of your counties to the north had 13% tax increases the 2 preceding years. Small, retired ladies and guys in this state couldn't live with 13% property tax increases. And that argument is still true today, so I don't apologize for having written an initiative that allowed the people to protect themselves from the cost of government. If I had my way, by the way, I would have done it the way I did 601. I'd also defended Initiative 601 in the Supreme Court. That was a melded average of population increase and inflation. Probably a more reasonable cap on government, but as it turned out, we had to go for a more dramatic cap on property taxes because of what was happening in those days. And finally, my favorite, the building industry. I'm proud to say I went to Harvard and I went to law school, and I worked my way through both, and I worked my way pounding nails with a 20-ounce hammer, working construction for home builders. My dad was a home builder, never built more than 4 or 5 houses in a year, so I don't view them as a big industry either. The suggestion here that somehow that they're something untoward about people who go out and work building houses, I disagree with. And I have had continuing support, but from them and others, because of my advocacy of private property rights. It is in our Constitution, after all. It's better protected in the Washington Constitution than it is in the federal Constitution for reasons that are historically obvious. People who came out here, like my ancestors on both sides, one came by boat from Sweden and one on wagon train, they came out here for land. There were homesteaders on both sides, and land was important. Liberty was important, and yes, guns too. I've still got a gun from my grandpa's, but so all those things are reflected in our Constitution. And in that respect, I am sincere and vehement about protecting those rights. But
you mentioned several people that support you and clients that you've had as an attorney, private practice, and every attorney, and yourself included, has, as you said, a diversity of clients. Do you feel that Mr. Johnson can't divorce himself from that when he's sitting on the bench?
Well, I can tell you this. There have been 17 cases where the Building Industry Association of Washington has submitted friend of the court briefs during Justice Johnson's tenure on the court. By the way, my family was in the home building business since before the Second World War. First my grandfather, then my uncle, and now my cousin is running the business. And I'm familiar with putting on the tool belt every day. And in fact, it just happened that I spent more time on our farm because I was better at farming than I was at carpentry. But so in these 17 cases, where the Building Industry Association of Washington, which far from being a mom and pop operation, is a large organization, statewide organization that lobbies for its membership. Nothing wrong with trade organizations, but my opponent took $200,000 in campaign contributions from the BIAW or their affiliates in the 2004 election. And then, instead of recusing himself, stepping back from those cases in which they have claimed an interest and submitted a brief to the court to advance that interest, which would seem to me to be logical when even if you try to be fair, there's certainly an appearance that when somebody gives you that much money and you sit on a case where they have an interest, maybe that's not the case for you. Maybe fairness would indicate that would be better decided by a more impartial or somebody who is not affiliated with the organization that's involved. Anyway, in those 17 cases, he voted with their position, either in the dissent or in the majority, 16 times. It's a 94% batting average. I don't think that any organization, large or small, is entitled to a sure bet on the court, and I believe that it was improper to go ahead and sit on a case where you have somebody that's given you that much money that's involved with the outcome.
Mr. Rumbaugh, what cases would you recuse yourself from because of contributions made to your campaign?
Well, well, now, of course, in '06, there were some new limitations that went on contributions into judicial campaigns. I personally believe that judicial campaigns should be publicly funded. That would remove the specter of special interests from the election. I know that there is pending now a rule that will establish a threshold above which you should recuse yourself if a donor is involved as a party or as an interested person or organization. In the case before the court, I don't know where the rule is going to end up. I don't think it'll be $1,000. I don't know if it's $10,000 or $20,000. I'm not sure where the final line is going to be, but there is a line there. And the line is clearly on this side of $200,000. And I believe that the appearance of fairness, so that everybody believes they're getting a fair shake in the courts, is just as important as getting a fair shake in the courts.
So would you recuse yourself from any case involving trial lawyers?
Well, since trial lawyers try virtually all of the cases in the state, that would be a difficult thing to do.
But they are supporting your campaign.
Individual trial lawyers, just like individual builders or individual business people, are supporting everybody's campaign. The question is, at what point does that support become tainted with the potential for abuse? And I don't think that a trial lawyer that writes me a check for $500 or a builder that writes my opponent a check for $500 is likely going to taint the outcome or have a result that appears to be unfair. But there is a line there someplace, and I would leave it to those who are studying the issue and who have made the proposal to draw that line, and when it's there, I'll abide by it.
But you drew the line for him.
Well, I think you draw the line at anything certainly north of $100,000 or $50,000.
Let's give Mr. Johnson a chance to answer that.
I'd be surprised and disappointed if the voters would select for a judge someone who plays hard and loose with the facts like he has just done. First, let's go back through the numbers. He did not say cases in which builders were involved. He said cases in which amicus briefs were filed. And I'll take his numbers at 16 of them over the last 6 years. I don't keep track of the numbers. I don't keep track of the hundreds of amicus briefs we get. Well, let's apply that to the over 700 cases I've sat on. It's a fairly diminished impact, it seems to me. And I'll tell you this story. We just talked about this in the last editorial board. Okay, here's one of those cases. You're familiar with Seattle, at least you go to baseball, football games there. You know the sinking ship there in the middle of Pioneer Square? There's an ugly garage. HTK was the first property rights case I had when I was on the court, and I did dissent. And the BIW did argue for private property rights. Here's the story. The owner of that property was taken out by the federal government and put into an internment camp. He was a Japanese American. He was put into an internment camp in the Second World War, and his neighbors were nice enough to pay his property tax, so he kept the property. So that property has been in the family for years. The yuppies in the Seattle monorail decided they wanted to have a monorail station on the corner, but weren't content to just take the property necessary to build a monorail station. They wanted to take the whole of the property because they had the plan that they could market that to the private companies that could develop the property and get more money out of it. So yes, I wrote a dissent, and my dissent called attention first. Under Washington's constitutional law, the first thing with respect to private property, it says, private property shall not be taken for private use. End of story. To me, that meant most of the property shouldn't be taken at all. Second, our Constitution says the question of whether it's a public use shall be a judicial decision. That is, we do not defer to the legislative bodies like the monorail. So yes, I wrote a dissent, and yes, the BIW supported it. I don't think it had anything to do with building. I think it had to do with private property rights, and I'm proud of the opinion, and the footnote in history here, by the way, they gave the property back too. I think I embarrassed the monorail, even though I did not get enough votes.